Welcome everyone to this webinar. I'm Rafael Carmona from the ICDR. And before we start, I want to take a moment of your time to remind you that you can join as an ICDR Young and International Associate or Y&I Associate. If you look for our website, ICDR Young and International, you'll find us. And in the website, you'll find registration forms in English and in Spanish, and you'll also be able to find the recordings of all of our previous webinars. You can also join our LinkedIn group. Again, if you look for ICDR Young and International, you will find it and you can request to join. We will be posting all of our updates there also. And I want to also thank first the organizers of this, our co-organizer, the Moot Alumni Association. I also want to thank Shashi Dalandas in particular for putting this together. And thank you to our panelists for participating today and to everyone who just joined. With that, I'll give the floor to our moderators, Lucila and Daniela. Lucila, Daniela, the floor is yours. Thanks.
Thank you very much, Rafael, and welcome everyone. As this conversation was advertised, this tries to be a very candid and honest discussion about diversity and inclusion in the context of being Latin, working in Latin America or working as a Latin in different jurisdictions. And before going into some of the discussions, we thought that it was going to be a good idea to introduce ourselves so you know who we are, what we do, and why Shashi invited us. I will start. My name is Lucila Marchini. I'm currently an associate at Herbert Smith Freehills. Or in New York. I'm originally from Argentina, but I have been between New York and London for a couple of years. I did my LLM in London, and then I joined HSF New York office. I did a secondment in London in the HSF office, and then came back. And I have been working for a couple of years before in New York. Before that, I worked a couple of years also as an associate in a firm in Argentina. And maybe Flavia, you can introduce yourself.
Well, hello everybody. It's a pleasure to be here today, especially in this webinar, being a lot in arbitration with dear colleagues that have had also like many challenges in the beginning of their career and managed to succeed so brightly. Well, my name is Flavia Mange. I'm currently a partner at Flavia Mange Advogados in São Paulo. As many of you, I started my career in Brazil. I got my first qualification in Brazil. During my law degree, I spent some time in Germany. I had attended a German school, so German was like my first foreign language. So I managed to have a bit of a knowledge on German law as well. And I moved to the US for an LLM. I did my LLM at NYU. I struggled getting a job in the US. And then I ended up in Paris working for Sherman Sterling and for Freshfields for a while. Then I decided to move back to Brazil, joined a well-known Brazilian arbitrator, started working as arbitral secretary. He moved to a big law firm. I moved with him to a big law firm. Then I decided to do a PhD. So I started my PhD in Brazil. I spent some time at HLS in the US again, during my doctor thesis. Then I moved back to Brazil again. I opened my own law firm like 7 years ago. Before I had other partners, now I'm mostly working as independent arbitrator. And it's a really pleasure to be here today and share a little bit of my path with you.
Maybe Juan, you can share your a brief introduction. Well, there are two Juans, so Juan Pablo.
Okay. That's what I was going to say. Which one? Sure. Hi, everyone. My name is Juan Pablo Moyano. I am a senior counsel at Holland & Knight in Mexico City. I am a Mexican attorney. I started out in Mexico doing mostly commercial litigation. I moved to London to do my LLM at Queen Mary. I worked in London for a while in an international arbitration law firm as well. After that, I moved to the US. I did another LLM at UM, the University of Miami. And then I also worked for a couple of years at the ICDR as a director for the Miami office. I am qualified in Mexico and in New York. And after all that, after my whole trip around the world, I decided to come back to Mexico and continue practicing international arbitration back in my home country.
Thank you, Juan. It is interesting from these two presentations, we already can see how many jurisdictions are involved in our background. So now, Juan Manuel, now is your turn.
Hi, everybody. My name is Juan Manuel. I am a partner in the International Arbitration Group at Cuatro Casas. I am currently in Santiago de Chile, but I am a dual Uruguayan US citizen. My main law degree is in Uruguay. And before this, I worked in another regional Latin American law firm. And for a couple of years at Clifford Chance in DC and at the ICDR before that. It's really, really great to be here today.
Thank you, Juan. And Daniela?
Yes. Hi, everybody. So as mentioned by Rafa, Lucila and I are going to be moderating this conversation. So I introduce myself in that quality. I am Daniela Páez. I am originally from Ecuador. I'm an Ecuadorian lawyer. I worked in Ecuador for 2 years. I came to do my LLM in the US 8 years ago and have been working for Herbert Smith for the last 8 years here in New York. So I'm not as diverse as my other colleagues, I guess. But we're going to be great. It's going to be great to hear from their experiences and their practices in different jurisdictions, as we mentioned, not only in the US. And we're ready to kick off the conversation. Just one logistical note, you will see that there's the Q&A. There's the Q&A tab at the bottom of the Zoom. So we are going to be receiving questions, and we're going to be asking them as we go through the conversation. So please feel free to add them in the chat or in the Q&A tab, and we'll be sure to answer them as we go along with this conversation and discussion. So to kick off the conversation, I think the first topic we wanted to address, and because we know some of the participants are students or moot enthusiasts that may be asking themselves how to break into arbitration being Latin, and whether there are different paths in arbitration to succeed with their background. So I open the floor for any comments from our panelists.
I think Flavia, you have do you want to start, or whoever?
Well, I can start maybe a little bit about how to job search in New York. Just like a very first point, I think you have to be very clear on what type of position you're applying. Are you applying for a foreign attorney position, or are you applying for a permanent position? And I think that will kind of like trigger how you put yourself in the market and what skills do you have to booster to be there. In my experience, at least like, I think my experience was quite a while ago. I finished my LLM in 2007. At the time, there were not so many opportunities to work with litigation and arbitration in the US, especially as a foreign attorney. Most of the US law firms were looking for transactional people from Brazil to contacts with their big Brazilian law firms. As you know, Brazil is not part of the Washington Convention, so we do not have that many opportunities in investment arbitration. So I ended up deciding to apply for positions in Europe. So they had more opportunities for commercial arbitration. And I think it's a bit different if you're applying for a permanent position than if you're applying for a foreign attorney position. And then I think that's the first point that I think I would like to put on the table, but there are many other.
My path at least was a little bit weird because I come from one of the small Latin American countries, from Uruguay, that maybe at the beginning doesn't attract that much business from big law, and it's not as attractive as other countries, even smaller countries that have bigger arbitration caseloads, such as maybe Ecuador for Daniela, and for me at the beginning it was super scary. That tell you the absolute truth. I did my LLM super young. I finished my LLM being 25 years old, and without real big support from my law firm, and I was lucky enough to be hired as a permanent associate at Giver Chance, and I made a career out of it afterwards. My first probably suggestion is to not think that going, the LLM route, then big law in New York or DC is the only way. It's been a while since I left, my LLM. I graduated in 2014, so it's going to be 9 years now. And since then, I've seen a huge uptick in cases being dealt from Europe with Latin American parties from Europe and even from Latin America. Maybe our practice is a good example of that. But other than that, there are many other options. Sometimes in Latin America, we're kind of, narrow-sighted with the US and thinking, you have to do the LLM and then to New York or DC, etc. There are great options. There are great places in Latin America where you can work. I'm very happy to see, for instance, one of the attendees is Laura Zielinski, that she's a French-German lawyer working in Mexico. Those kind of things, back in the day, those kind of things didn't happen. And my first suggestion is to be open-minded about to actually, do the work. Just don't go the typical route. And bueno, Juan Pablo, you're a very good example of that as well.
Yeah, no, I was gonna say, so the LLM, I think, is, as you said, Juan, is the traditional way, is what everyone would say, like, how do you break into arbitration? Do an LLM. And I don't think that's necessarily true. There are so many ways to break into arbitration, such a huge field nowadays. There are a lot of attorneys, I think, and you probably know a lot of attorneys in your respective jurisdictions that do arbitration that don't necessarily have an LLM in international arbitration. Maybe they'll have a master's in something else, or maybe they won't even have a master's. Some of them just enter the field by working at certain law firms and start getting the experience from there. I think a good takeaway, as you said, Juan, is there is no one way to break into international arbitration. It's such a rich and expansive field that you can try it out. You can try to get into it many different ways. There's no set rules. And what's better is that there are no set rules in any one country. You can try to do it in your own jurisdiction. You can try to do it somewhere else. You can try to do it in the US, in Europe, in wherever you want to, and try to change countries in that. I know a lot of, for example, a colleague of mine back in London is now practicing arbitration in Japan. She's not Japanese. She just decided to move there to practice arbitration over there. So stuff like that happens, and I think it's very interesting to see.
Yeah, I think one takeaway is that you have to be flexible and open-minded. Basically, like, I also wanted to work in the US, and I ended up working in Paris. And looking now with some distance, it was actually a much better experience than if I had worked in the US. So I think at the time you're like in your early 20s, you think, oh, my only option is like do the moot and do an LLM, work in New York. And we can see here like Juan Manuel working in Chile, having a lot of experience with international arbitration. Juan Pablo also like back in Mexico. I'm back in São Paulo. And probably now in our own jurisdictions, there are already opportunities for you to get yourself out in the market and have experience working in arbitration. Even like when I went to law school in Brazil, non-Brazilian law schools will even attend the moot. I did the moot only in 2006 when I was at NYU, but now you can start like doing the moot, doing even domestic moots. Like in Brazil, we have like also domestic arbitration moots applying Brazilian law. And it's a way for you to start getting experience. And that counts a lot, even later on, if you are working abroad.
Yes, I think that I completely agree with the flexibility, because that was happened to me. So I went to London and I thought that I was going to work for 3 months in London, do an internship and then go back to Argentina. And then my path was completely different. I ended up studying in London, but then working in the US. I never expected to work in the US. I didn't at the time when I was choosing between studying in the US, studying in Europe, I decided to go to Europe. And then when I received a phone call from HSF saying, do you want to go to New York? The first thing that I said is like, oh yeah, why not? So I think that even if in my mindset, that was my plan, one of the key issues that I think allowed me to go to this path was to be open and flexible about, doing different things in different places. And that's the beauty, I think, of arbitration.
I have like a good example of this on my former Moody's team. So the four of us that we did a Vis Moot, the four of us have done careers in arbitration, but very different paths. So I did what I did. Santiago Atiga is a good friend of mine. He went to live to China for like 2 years, then he's LLM at Harvard, and he's now at Freshfields. Victoria Narancio got hired directly from Wilmer Hale. She got hired directly at one of, I think it was like the semifinal from the Moot, and she ended up being a counsel at Wilmer Hale, and she's now doing something completely different. And Sofia Claude, she stayed in Uruguay and did the LLM and Harvard. Then she left doing like pro bono stuff and human rights stuff, and now she's at Freshfields. You know, there are very different paths. Oh, and sorry, and Yael Ripko, she did her LLM at Holland, then worked in Paris for many years, and now she works with Yasban Fatem. You know, and it basically the same 4 kids from the same neighborhood in Montevideo doing international arbitration, but with very different ways.
And I think, maybe it's something to pick up, I think that now our jurisdictions in Latin America are very well developed in arbitration and that's something that Flavia mentioned, compared to when I was studying at law school. I think that we had the option to do the Moot, but that was the closest thing to be doing arbitration. And now I think that the jurisdictions have evolved. All the jurisdictions, or most of the jurisdictions in Latin America, have new arbitration laws. And sometimes I have seen contracts with the seat of arbitration, not in New York anymore, not in Europe, but in Latin America. So I think that there are a lot of possibilities, not even if you don't have the chance to go and study abroad for many reasons, to develop your career locally. So I think that that's a good thing for us. Even if you don't have that chance, I think that there are still possibilities to develop your career back home.
Yeah, to that point, if I may add something, what I have seen in Brazil, not even recently, that was maybe even like 5 years ago, were many arbitration clauses providing for arbitration in Paris or New York, and the parties agreeing at the outset of the arbitration, well, both parties are Brazilian counsel or subsidiaries of international companies, but we've had with Brazilian companies, and then they decided to do the arbitration in Brazil because it was less expensive or several other reasons. And nowadays we don't even have that much of these cases because the parties already agreed to have to sit in Brazil with arbitration clause. But that had happened like maybe 5 or 6 years ago, and then we had like the ICC coming to Brazil, having a offices here, and also like many other institutions internationally looking for Latin America as a good spot for arbitration as well.
So if I may add to that a little bit. So I think ultimately, and let's not joke about this. Arbitration is a difficult field in a way to enter because there are so many people doing arbitration. The market expands, of course, it is growing, but at the same time, so are the number of people that want to participate. So it is difficult in a way. Many ways to do this, as we said, LLM, working in your own jurisdiction, trying to get experience abroad, trying to get experience at a foreign law firm somewhere. One thing that I would add that was part of my own experience was working at an institution. They usually don't have a lot of opportunities, but they are there. And there are many great international arbitration institutions. Even within your own jurisdictions, maybe your own local institutions may have an opportunity for you to participate. And this is a great way to learn about it. I used to joke with the people at ICDR that every day doing arbitration at the ICDR was like a mini LLM, because you would get so many bizarre things happening in your cases all the time that you would never know what attorneys were going to come up with. So it's just one of those things that people often forget, but they're great opportunities as well.
It reminds me of something that happened to me while I was studying in London. So when I was studying at UCL, we didn't have the job fair. That's something that I discovered when I moved to the US. So basically, you have to do your own path and find out a job for yourself, because everything is focused on a training program, which is completely different from what we are used to, because we are already lawyers back in our jurisdiction. So while I was in the exam period, I had to, it came to me that a great idea, an extra work. So I did a huge table with all the firms that I wanted to work. And something that I did is, well, I speak Spanish, typical. being Latin. So what I can offer to this firm. So I was checking most of the cases, commercial cases are confidential, but those that are public in investment arbitration, I check which firms in London had cases dealing with Latin America or some contract with, but they will require Spanish speaker. So I made a note of all of this, and I try not to be shy, and I contacted the partners, sent emails. Some of the partners were great, and they came to me, reply, and say, hey, let's have a lunch and discuss. So I went with my magnificent table to one of the partners with the list of things that I wanted to do. And this is on the point that Juan was making. He said, but you don't have any institution here. And I said, no, because I really want to work in a law firm. But look, working in an institution is great because you will meet a lot of people. I mean, that's where arbitrators go. That's where the counsel goes. So that's another possibility that you are not even considering. So then I said, yeah, that's true. So I was 2 days before the deadline to apply to the LCIA, and I rushed to apply. Well, I ended up working in HSS, but in the end, I was on the whole process. So I think that's part of the first premise that we discuss of being flexible and think about different possibilities. So that's a story that happened to me.
If I may add something to that.
Sorry, Flavia, go ahead.
No, go ahead, Juan. No, I had also like a short experience at the ICC as an intern, and especially working in the Latin American team was quite interesting because basically at that point, it was 2007, if I'm not mistaken, people in the European teams, arbitration was like going smoothly and everything was like going well. In the Latin American team at the time, we had Cristian Canojeros, Jose Ricardo, and like our cases were like all different. We all had to kind of like, well, what are we doing here? Is like, it's not only 2 parties, and I think that were not at the time in the rules. And I know some of the things that led to the change in the ICC 2012 rules came from the Latin American team, because we had the challenges that we were like having to dealing with like non-traditional ways of having an arbitral proceeding or like multiple parties or whatever that at that time was not that common in other regions. So it was a great experience as well.
Think about the names that left that team. So ICA
exactly
back then. So it was Cristian Conejero, my partner now, Eduardo Silva Romero, and from that list it goes on and on and on.
And even before, I worked later on. I ended up working with Fernando Mentila Serrano, and he even before Jose Ricardo was there.
Ricardo, you know, there are great names.
Eduardo Silva Romero, yeah.
My first job in arbitration was a month after graduating, when Shashi and all these good people at the ICDR hired me. We, for instance, we at Cuatro Casas, very influenced by Cristian, we value work at that institutional level like a lot. So it's super important for us.
I think
another.
Lucila touched on something very important, and I think that's a good point of focus for us, because at the end of the day, as Latin Americans, when we're looking for an opportunity in arbitration, we focus on our strengths. When you're a recent graduate and you really don't have much experience, and you look at things like, well, I speak Spanish, I come from a civil law jurisdiction, what can I do? What can I offer law firms? So you look for jurisdictions that have business with Latin America or your own country. You look for law firms that have cases in your jurisdiction. And I think that's natural. I'm pretty sure, I can almost bet that everyone here tried to do that at some point. I know that I did, and I did exactly what you did. I also had my list of law firms. I sent dozens of CVs to all the law firms that I thought that had arbitrations with Mexico. And I got an answer back from like 20% of them. But that's what you try to do, and I think it's natural. And particularly when you're starting out and you don't have experience, when you don't have prior work in law firms or an institution or articles or your LLM or whatever it is, I think that's natural, and it's still something that you need to try out. Sometimes it works, sometimes it doesn't, but you do need to try it out.
But I think that, and I thought that it was going to be, you know, for me at least, only working with Latin America, but I found out that I ended up working in other jurisdictions with civil law. So I ended up helping teams with, for example, reports that were done under Egyptian law, because the system is very similar. The civil code, even if it is in Arabic, contains similar provisions to our code. So I expanded a little bit, and I think that that's something that, well, it didn't occur to me at the time, that it doesn't need to be only countries from Latin America. I think that coming from a civil law tradition also helps with cases in completely different jurisdictions. But at the time, I didn't know that, or I was not thinking about it. And then it was, well, that could have been another selling point.
Yeah,
Yeah,
and just, oh, sorry.
Go ahead, Daniela. No, go ahead, please.
No, I just wanted to comment on Juan Pablo's last comment about the experience. Sometimes we as Latin Americans are not confident enough about our years of experience or what we did in Latin America. But when you come to the US and you compare yourself with or in London with a trainee or with a first-year associate who have no experience at all, I think that is valued, because sometimes when we do our LLMs, we have, a couple of years of experience, if not more, and we have judgment. We know how things work. We have a commercial mindset, which are things that in the end are valued, and we see it now in our practice. It's very different to work with someone with no experience at all, that someone that had a couple of years of experience in their local jurisdiction. It really makes a difference in terms of the judgment to do things, everything, because you've been through a client instruction, a client email, a client meeting, like interviewing a witness, little things that are valued when you're working in an international law firm. So that is to say, we sometimes bring ourselves down and say, oh, but that they don't care about my experience back home. They don't care that I work in Spanish or that I work on all of these cases back home, because it was not an international arbitration. But I do think that is valued in the way of that value, of that experience of the candidates. So that's what I
totally agree with you, Daniela. I had the same impression when I was working in Paris. After my LLM, I was like in an entry-level position, but I had prior experience only with litigation, because at that point in Brazil, that was what you could get. But it did add value to my work in an entry-level position in an American law firm in Europe. So I totally agree with that even transactional or litigation or any other experience you can have, on your own country, it's super valuable, and you have to be proud of that.
And to tell you the truth, I mean, and this is something for me that is kind of even philosophical, and it's the reason why I decided to make the move from the States back to South America. When you review, like, many of the big LATAM teams are headed by Latin American lawyers, right? There isn't anything that Latin American lawyers, know that are inferior or any way not at least equal to US and Europe-based lawyers. We know that. That's why most of the biggest, Decker teams or whatever are Colombian, Spanish, Argentinian, or Lucila and Daniela here. There isn't any reason why you need to think that you will learn more with, Americans or British or whatever nationalities. You are as good as anybody else. Latin American arbitration is being handled by Latin American practitioners in New York or somewhere else, and we really need to, own that self-worth, because 20 years from now, 30 years from now, it's gonna be very unlikely, that big ticket Latin American arbitrations are being held outside of Latin America, because basically everything is catching up to that point, So I think that it's something that, at least for me, philosophically, is super important.
And now we have been talking about what we can offer to the market and as Latins and the different options, but we are moving to a more difficult topic, maybe, but I appreciate that we all be honest and share experiences. Do you think that the fact of being Latin has had any negative connotation while you were working, or working as an associate, working in institutions, and whether you have experienced any situation in which that could have happened? This is a tough one. I see some laughs.
I can start if you guys want. I've never had working like a bad experience, but searching for work it was tough, right? So when I was at the LM, I remember I did like 10 or close to 10 search, like formal proceedings with law firms, and countless, can I get you for coffee, at 3 p.m. to X and Y partners in literally every single firm that I could think of. And I did exactly the same as Lucila. I started looking, at the exit caseloads to see the Latin American cases. I started to see, whatever parties that I remember from the ICDR that had, Latin American cases, et cetera, and I had 20,000, well, we're not really, with a big caseload of Latin American parties, et cetera. And the biggest thing to me at that moment was like, I don't care. I mean, I do international arbitration. I don't do, like exclusively Latin American cases. Latin America is a very big place. It's very different in Uruguay and in El Salvador, in Mexico, and Brazil, and whatever. You just need to do, this is, how to do the work, not the law. The law you can learn. What you need is how to learn the process, and that's it. And that was really hard. At the beginning, it was really, having those conversations with firms that had, multi-billion-dollar cases, I don't know, in Egypt, like Lucila said, or whatever. And at least for me in that moment, we're not really interested, or we are really interested in a Brazilian because we have a lot of Brazilian cases, but we don't have, other cases, or we are really interested in a Mexican because we have Mexican cases. That was hard.
Yeah, I can echo that, definitely. My initial experiences in working in international arbitration were very much like that. Basically saying, oh, you're Latin American, therefore you will only do things that require Spanish research. If it involves looking for stuff in Spanish, that's yours. Everything else, you're not involved. Cases in Germany or cases in other parts of Europe, nothing to do with you. And that became a problem because you start getting shoehorned into things that have to do with a language more than your capacity as an attorney. And even nowadays, it sometimes happens that people look for me because there are issues that relate to Spanish language or even just to Mexico, not necessarily to international arbitration. So that is something that is very pervasive, I think. As Latins, we tend to be shoehorned into this idea that we can only do it in Spanish.
Well, I have two comments on that. I think the first comment, it's like, well, I'm a Latin, but I'm Brazilian. So do I fit into a Latin American team? I was always like, especially when I was job searching, now I do speak some Spanish. At that time, my Spanish was very poor. And I was like, well, but can you work in Argentinian cases, in investment cases? And I was like, wow. So I think that is one advice I always give to young Brazilians. You have to have like a really good Spanish to kind of fit into a Latin American team and be able to transit in between cases with Brazil and cases with Latin America. Although Brazil is a big country and there is a big number of cases out there, people think there are more than it is really. But I have a very practical example when I was job searching that was really like into, maybe I think the law firm was trying to do like administrative issues and deal with like work permit, but I was looking for jobs in Europe, as I mentioned. I had finished my LLM. I could have stayed in the US with the OPT for a year, but I didn't find any job in New York. So I was applying for positions in Paris. And then I think it was like really like the day before the New York bar, I got an email from a law firm in Europe with the following sentence. Ms. Something is willing to make you an offer and inquire whether I had any European nationality, which I did not. So I was like, that was like really the day before the bar. And I was like, well, do I have an offer or I don't have an offer? I don't have any European nationality. It was very uncomfortable because I was like under the impression I would only get a job in Europe if I had any European nationality, which is quite common from a lot of Brazilians and Latin Americans, but I didn't have one. I still don't have one. So at that point, and we ended up managing to get a work permit like later on with another firm, but that was something very like nationality oriented.
Yeah, and I think that, and I was trying to think another, not negative connotation, but in hand with what Juan Pablo said about, you only do work in Spanish. So I think that I share in a small team that once there was an arbitration ongoing that I was not involved, so it was handled by all American people, and it happened to be related to Latin America, but there was no one from Latin America in that team. So they got a bunch of Spanish documents, and I was already, I think, advanced in my career, and there was a bunch of documents, all in, actually, I can't remember if they were from Mexico, but you know, those documents that go through the notary, which are like letter 10, very small, very tedious, you know how we do things in Latin America. So they asked me, can you please translate this in today? I was like, no. You know, probably if it was at really beginning of my career, I will say, yes, of course, I will do it very quickly. But then, you know, with the years, I learned to say, no. I mean, that's not the only thing I do. I mean, that's the work for the translators, and they know how to do it. I am a lawyer, so I'm focused on law. If you want me to help, I will be happy to join the team and help you to understand what's the relevance of this document, how these documents can support your claim or are against your claim or whatever. But our role is more than just reading documents in Spanish and providing translations. And that's something that have happened and maybe will happen again, I don't know, in other contexts. So my lesson learned, because I had this situation before that, and I always say, yes, it's like, you know, we are lawyers that did a huge effort. We studied in our local jurisdictions, then we try to break into this world of arbitration. We learn other languages. So I do more than just speaking Spanish and translating documents. So at the time I didn't have the guts to say that, but I think that as I develop in my career, I think that I got the strength to say, well, no, that's something that I don't do. I can help you. I can join the team. I can help you with these documents and everything that is related to this Latin American country, but more from a lawyer perspective than just be a mere translator. That was from my experience.
And that goes to the point, I think, what we were discussing earlier, right? Like to note the self-worth that you'll have, like coming from Latin America, and you guys are all great lawyers, and you have exactly what it takes to be great arbitration counsel, and not just, you know, glorified translators, as Lucila was saying. And I think it's really nice to actually, you know, go into the websites of the main arbitration teams. Go and see that Decker, Teodoro Silva Romero, Leithan Watkins, Fernando Mantilla Serrano. Go to Covington in Argentina and the Chilean, you know, are leading the teams, etc., etc., etc. There are a lot of great LATAM practitioners, and they made it through all of this, right? So they are now, I mean, they're great lawyers, but they're not better than any of you guys that are listening to this right now. So if those guys could do it, we all can, and that is super important.
I wanted to pick up a question that somebody threw in the chat, by the way, which deals with work permits and visas. And I think I at least wanted to talk about it because that was an experience that I had. Not necessarily a Latin American issue, but I think it's something that most of us face at some point. And that's because the reality of working outside your own country involves either being a national of another country or having a work permit, a visa. And that's something that you cannot evade, no matter how much you try. I remember, for example, when I was in London, that I lost a lot of job offers because I don't have a European nationality. And that I knew that there were other Latin Americans that have a dual citizenship that would get jobs like that, and it makes sense because it's cheaper for law firms to get someone that is a national of the country or the European Union than to actually get you a visa. So issues like that is something that unfortunately you do have to consider as part of your practice when you go forward. And there's really no way around it. It's just one of those things that you have to learn to live with if you don't have another nationality.
Exactly. Let's say, go ahead, Juan. No, it works both ways. I know a lot of foreigners that want to work in Brazil, even like are here and have issues, especially because of how law firms are organized. We are like members of the bar, and then we have a special type of corporate that is only allowed to be partner if you are a member of the bar, and then it's difficult to put a non-member of the Brazilian bar within a partnership of the law firm. there is a lot of different issues also within our own countries for foreigners to work. And I think Juan Manuel probably have faced some of that in Chile.
Totally. I mean, for instance, I had less trouble, like I'm absolutely certain that a big percent of Clifford Chance's decision to hire me is because I was born in the States by some accident of, destiny. Because I grew up in Uruguay and I'm Uruguayan to all extent. But also, having said that, I think that the post-COVID world is also showing some, other opportunities, right? So, like, for instance, we hired and we have here living in Chile with us a former PCA counsel that she's absolutely great, and it was in the middle of the pandemic. And for the first year, she worked, remotely from Uruguay, and there was no problem. I have a lot of friends living half time between New York and some other place, and those things are starting to change. Brazil, regrettably, I think it's probably like one of the toughest places to be in the world, but there are other options, right? So firms are starting to grow from like outside of the typical hubs. So I always love the example of Noyana Marigo. She's like the absolute rock star at Freshfields. She's living in Madrid right now, and that will start to happen more and more and more. And with that, there are other great opportunities, right? So like visas in the States is probably like the hardest place. We all have friends, that suffer the H-1B visa, lottery, and they lost and had to go somewhere else for a year. And so that is still a reality, but I want to think that will start to change eventually.
And I think that what you were saying, Juan, that, this thing that, that coming from the US, going to Madrid, the other way around, and that goes in line with one of the questions that we got about, doing an LLM outside the US and then coming to the US. But that was my my path, actually, because I did my LLM in London, as I said, and then I moved to the US and I was having my LLM on international law from UCL. And I think that my case was, there was a little bit of luck. You have to contribute to that, but because the time that I was working, Daniela was working here in the US with the team, and the times when you finish your LLM in Europe is different from when you finish an LLM here. So they were in need of someone from Latin America, speaking Spanish, talking about those topics, but speaking Spanish and with a background in international law, because we were doing an investor state case. And it happened to be that I checked the boxes and I was in London, and the time worked because I was finishing my master in September, and then I could fly here to join the team. So I think that there are possibilities. There is one question, I think, about the visa. I think that was another question that we received. Of course, when you come and you decide to study in the US, you have the OPT. That's what I learned when I moved here. You have the OPT and everything. And that's something, and as I said, this is going to be an honest and candid discussion. That was an issue for me because I was coming from Europe. So far, I have gone through a lot of visa processes here in the US. So I think that now, apart from arbitration, I can do immigration law because I know all about visas. So I have gone through all the embassies and check all the visas that are available. But yes, it's tough. So it's not only about moving countries, it's also about being open, that you have to deal with a lot of paperwork, but there are possibilities. So when I came here, I joined with a J1 visa. Then I had to go to London because there was a gap that they couldn't, I didn't get the H1B because I didn't study here. So then they had to send me to London to be able then to transfer me to the US. So yes, it's a complex issue, but if you are looking to have a couple of years of practicing and then you will see what happens, I think that there are visas that would allow you to do that. So first, to sum up, I don't think that having an LLM from non-US university will not allow you to work here. That was my case. I have my LLM from England and it worked. And second, there are visas. It's a matter of finding out which is the correct one for you. And I think that there was a third question about whether you need to be admitted to practice. And I think that that goes in line with my experience. So I studied in London, so I was not, I didn't do the normal path of, you know, the courses that you need to take the bar. So if you want to focus only on international law and you do not do commercial arbitration, New York law, hardcore, you do not necessarily need to be admitted, but that would, I mean, and it's up to you, that would limit maybe the focus of your career to only do international law. If you really want to do a mix of commercial and investor state, that's something that you, I mean, coming from abroad, you might need to consider when you don't have an LLM. And that's also my situation. So I had to do, you know, the courses at university that will allow me to sit for the bar, because what I had in London was not enough in order to be admitted in New York. So that's another point to consider. And I think that I covered some of the questions that were in the panel. I don't know if anyone here had a different view of
there are also firms that kind of ask you to be barred for like more of a regulatory perspective, right? So in DC, you need to be like admitted as a special legal consultant, regardless of where's your original. There are other firms that kind of ask you, in order to keep, you know, the permanent associate track, to be barred in a US. You know, it goes more to not really if you need it, but also what your employer is asking you. That doesn't mean that you cannot live without that, but yeah, I mean, I know a lot of firms that ask.
Yeah, and actually, one thing that I've seen a lot lately, at least, is that a lot of job offerings from the U.S., some law firms require you to be barred in the jurisdiction to which you're applying. So if they have office in New York or California and D.C., and they have an arbitration position open, you have to apply to the office in which you are barred. So that also becomes an issue, because, for example, some of us that have the New York bar, we may not have sufficient credits from back at the time when we did our LM to get the DC bar or something similar. In a way, this also is an issue because there are other jurisdictions that are a little bit more restrictive to that, like Florida, for example, which I think until recently they didn't accept LLMs to get to be certified with the board. So it is a complicated network of issues that you do need to swim through, and usually I think my best, what I could recommend of that is to get close to someone that has gone through it, like Lucila said, because it is difficult to navigate.
Yeah,
that happens not only in the US, like if you're in France, you might need to get also like admitted there. Also for foreigners to be in Brazil, they need at least to get this like foreign consultancy position before the Brazilian bar. I think it really depends on where you want to be in long term, but to work in international arbitration per se, you don't need it, but it's always also like on one side, if you are like applying, for example, for an arbitration, to be appointed as an arbitrator, for you to have some exposure both in common law and civil law, be qualified in a civil law country and in a common law country, that will boost your career as well. So I think, well, at least when I passed the bar, like the partner I was working for, he was like, well, I don't care that you pass the New York bar, but it's important that if I give you a task, I know you will be able to like sit down and study and handle it. It's just like, it's a standard exam. So they were like, okay, like, I know it can, if you handle the bar, you can handle like a test if you are given sufficient time to sit down and study and whatever.
But after saying all of that, I've been here in Chile for 6 years. I've only done one Chilean case law in my life, and I have absolutely no clue what Chilean law says. Now, I mean, I do know, but I'm not barred in Chile, and it's not been a problem. I do international work, and that's it. You know, to each their own, and everyone has different, you know, requirements and needs for their careers.
I would just add that if you are considering the US and if you are considering an LLM in the US, as on the side of the employer, normally employers do take candidates a bit more serious if they are considering sitting for the bar exam, because it's just an international certificate that you pass this exam. It's a very difficult exam. It's in another language. It's a common law jurisdiction. And if you have this, or you're willing at least to take it, to make an investment, because it's not an easy one or not a cheap one, then I think it is appreciated by employers or by partners when they are recruiting. Sometimes it is a criteria we would look forward in a candidate just to appreciate the seriousness they're taking this LLM and this position. So I do think if you have the resources, the time, it is something worth doing after you're already studying for a year in a different language. You have the mindset of a student that you will never have after you go back to practice. I do think it's a very serious option to be taking if you want to also stay long term in the US. And I think at least for New York, you can do it through the after doing the LLM. In other jurisdictions like Florida, it's much more difficult. You need to be, I think. The rule recently changed, but normally you would have to study there the whole law school, the 3 years, to be able to get the bar there. And of course, as we know, a lot of firms and a lot of things are going on now in Miami, where a lot of practitioners have been moved down there and trying to get qualified. We understand to be able to practice in Miami, even if they're doing international arbitration. So I think with that, we can conclude the bar, the license debate, and maybe move to another question that I'd like to pose to the panel. Do you think there is a cultural barrier that needs to be overcome when working in a different jurisdiction or with people coming from a different jurisdiction? So maybe, I don't know, Juan Pablo, would you like to start? Putting you in the spotlight.
I think in a way it is. So as I said, it comes a little bit mixed with the language issue and with the fact that you're marked as a Latin American lawyer. The cultural barrier, I think, works both ways. And on one hand, they see you as a Latin American, and that's it, right? And that's a possibility that you're marked as that. And an issue with that is that you may be asked to do law from any Latin American country whatsoever, no distinction. As Juan Manuel said, he doesn't know anything about Chilean law. I can't imagine learning a whole new system. And that sometimes becomes an issue, also an advantage. We've been complaining that, yeah, we do international arbitration, and therefore we can do any type of legal analysis for arbitrations. But at the same time, sometimes all of Latin America is bundled together and says like, oh, here you go. This is a Latin case. Handle it, even if it's a law from a different jurisdiction. So I think it's an issue that works both ways. I think I would be very interesting to hear what Flavia has to say on this, because obviously, as Spanish speaker, I tend to think about Latin America as Spanish speaking, and sometimes we forget that Brazil speaks Portuguese, and it's a massive jurisdiction with a lot of arbitration.
Well, I can say the same about Brazil and like Portugal or Portuguese-speaking countries in Africa, because they are also like similar in some way, but very different in other ways. And I think like right now we have a lot of Portuguese people come, and it's interesting that move, because right now I think we do have more Brazil speak, and I think we are doing well, and we have more cases maybe than in Portugal. We see a lot of Portuguese arbitrators coming to Brazil to work here. And that's exactly like the opposite of what happened in many other countries. That very first case I worked in Paris, we had a Portuguese chair, and we had even like some issues with translation, because Portuguese from Portugal has some different words than Portuguese from Brazil. And at the middle of the hearing, like the translator was translating a very important word of the case, like to Portuguese from Portugal, and it didn't make sense to Brazilian Portuguese. So, but at the end of the day, like there are many concepts that I think, like good faith, for example, there are a lot of things from Brazil, from Portuguese authors that can be brought into Brazil, and since we share the same language, it's for us much easier to understand their legal system. And then once you understand the Portuguese legal system, like you go to Mozambique, Angola, they kind of like have very similar systems from the Portuguese legal system, although they are also like different. And sometimes they would prefer a Brazilian arbitrator than a Portuguese arbitrator, because they kind of see, oh, colony, and we don't want to get a Portuguese. I don't know, but there are opportunities as well. So I totally agree with Juan Pablo. It can go both ways. It can sometimes be mixed together as like, oh, it's all the same, but on the other side, you can definitely work in that market easily than an American.
I think that on something that we briefly discussed when we met yesterday is about how other jurisdictions perceive our jurisdiction and the different concepts that we have compared, for example, to common law. And sometimes, and this is from prior experiences, very difficult to try to explain to someone coming from common law about our main concepts. And sometimes the reactions that I get when that happens is like, what is that? Doesn't exist in the US. I don't understand why this decision is written the way it is. This is how they write in Latin America. So a lot of these kind of comments. So I think that I agree to say, I mean, I'm convinced that we are always very open, and that's something that we discussed with Juan Manuel yesterday. I think that you mentioned that we are always open and we don't question about common law. We study, we learn, not from our perspective, or we try to learn as something new, and we don't try to compare and translate it to our system. But I feel that that doesn't happen when it's the other way around. It's always questioning, but what is administrative law? I mean, I don't understand what is the administrative proceeding, an acto administrativo, you know, administrative act, things like that. And the reaction is not, oh, I want to learn more about how it works in Argentina. It's just, I don't understand. No, it doesn't exist. So I think that it's a huge cultural barrier, especially when you are working in a case, because it's very, I mean, if it is difficult to explain to another colleague coming from a common law jurisdiction, imagine to an arbitrator who doesn't have anything to do with Latin America or a judge. So I think that that's from my perspective, one of the main barriers.
And there is a very real, I think, and real to some extent and implied to some other, like, and I don't want to be like a revolutionary here, but to some sort of like legal imperialism to the extent that we go into, you know, and I think that's why Latin American arbitration practitioners are so good, because we go, you know, into common law from scratch and we try to learn it and try not to equate it. And we've all been in discussions, you know, with not just common law lawyers. I had it with civil law lawyers, but not from Latin America, but from European or other jurisdictions. Like, you explain something from El Salvador or whatever, and it's like, yeah, but that's this other concept that they have, right? They try to match with what they have in their own background to something else, and that's not really applicable, right? So that is something to be overcome, you know, just trying to relax and trying to explain that, you know, no, yeah, we have acto administrativo is actually a really cool thing, and I wanted to explain that. But also, sometimes when we are explaining our own laws, we kind of, you know, we bring ourselves down, and this is a typical, you know, Uruguayan decision, and it's really bad, and don't worry about it, I will explain to you later. No, it's probably really good, and it's probably better than many other, you know, first world decisions, and you know, that is the same self-love that we've been discussing before.
I think just to add to that, for example, in my case, one thing that I've ended up doing a lot in my professional career lately is working as a translator of legal concepts. And for example, when I work with partners or with clients from the US, a big part of my work, of everyday work, is to just translate civil law concepts to similar concepts in common law that make sense to them, because otherwise I feel like it just doesn't fit. So it's interesting what Manuel said, because I don't know if it would work the other way around. So things like trying to explain what an amparo is, or what something similar to an injunction in Mexico would be, those kind of ideas, or try to fit it within their procedural frame mind. It's interesting in a way, and it's definitely a cultural barrier that I'm not sure if it goes, like I said, the other way around.
You know what I've done, and this is something that I'm particularly proud of. At the beginning of my career, I used to look for the equivalent, and now I just write amparo in italics. It's its own thing, right? It's not a constitutional law injunction. It's an amparo, you know? And I've been like really adamant on this with our teams.
I'm gonna start doing that. I like it.
Great. I think we are about we are at 9 a.m. There was just one last question in the Q&A. Which states in the U.S. offer most opportunities for Latin American lawyers to practice international arbitration? I will just say, from my perspective, that would be DC, New York, Miami, with the limitations I've said. I think there's more and more going on, maybe in jurisdictions in Texas, maybe Houston, Austin, California, San Francisco, but I think, those are up and coming. I don't know if people want to add others or have different views so we can conclude.
No, I would actually just reiterate on Texas because of the energy arbitration, because the energy arbitration disputes there are countless. So that's definitely something to consider.
And probably very much focused on Mexico as well, right? Like there are a lot of tech companies working in Mexico.
I may be biased a little bit there, but yes, I guess it would be a lot very focused in Mexico. You're right.
And I would just add that there are like other spots outside of the US that you can also work with arbitration, especially international commercial arbitration, if you are Latin.
I think that
even within Latin America, we have Juan Manuel like as a good example of like commuting. And I do think we have to, especially Brazilians, interact more with our fellow Latin American countries.
And I think that unfortunately we reached the hour. And I know that there were a couple of more questions that we were not able to answer because we were engaged in the discussion. And thank you so much for being so honest and candid about your feelings, your experiences, and what you had gone through. And I will welcome everyone that is attending this webinar. If you have any questions, you want to continue the chat, you can contact us. We are available, and you can send us an email, and we will be happy to continue the conversation. I think that it's very important that we are considering these issues of diversity and inclusion in the arbitration community, and I'm happy that we had the chance to do it from a Latin American perspective, but it doesn't stop in 1 hour of conversation. So I will be happy to keep the discussion going with any of you. So please feel free to send us an email, and we will be happy to talk. Thank you very much, all of you.
Thank you. Have a good one.
Thank you. Bye.
Bye.